Good morning, everyone. This is Prashant Pinnamaneni, Secretary for NATS Board of Directors 2020 to 2021. First, I want to thank Allan Gassman, our speaker, and all participants for taking time in attending this webinar. Before I hand over to Allan Gassman, I have a couple of housekeeping items. First, I want to thank my team who did the heavy lifting behind the scenes. Srinivas Malladi, Rajesh Kandro, Sudhir Mikilneni, and Vijay Konda from Cloud Milo, and Allan's team, Debbie, Matt, Tina, for doing all the logistic support and to make this happen on such a short notice. Thank you, everyone. And I would like to take a minute to speak about NATS. NATS is a non-profit organization for Telugus in USA. Primary objective of NATS is to do service. We address the needs and concerns that affect the daily lives of Telugu people. We provide social, financial, and education support for the community. NATS conducts various programs like Balal Sambralu, Mailal Sambralu, Coffee with Cop, tax seminars, will and trust seminars, health awareness seminars, food drive events, technology seminars, pathway for student seminars, a lot of sports events in different chapters all over the US. We also conduct NATS Sambralu convention every 2 years in different places. Our main team in NATS is the helpline team. NATS helpline team supports victims and families in unfortunate incidents. We do offer a lot of support when an accident and death happens, or immigration assistance, or medical assistance and domestic violence victim support. If you come across anyone who needs any kind of help, please have them reach out to helpline@natsworld.org. Once again, the email is helpline@natsworld.org, or they can call us at 732-444-2121, and our website is natsworld.org. So coming now, like why this will, trust and estate seminar, and mainly now. NATS has been conducting this seminar from many years at different chapters all over the US, but this is the first time we are conducting a webinar with Allan's team. Unfortunately, we have seen an increase in number of fatal incidents which are occurring in our community, where the surviving family members and young children get left behind. They're scared, lost, and even overwhelmed. To make such an unfortunate situation even more tragic, most of the deceased loved ones do not have a will or trust already set up, resulting in the possibility of minors having to end up in foster care, and also the family members have to deal with the necessary court work, court paperwork, probate process to handle their assets, which is a very lengthy process and time-consuming process. NATS initiated this webinar with Allan. The main purpose of this is to educate all of you and help provide resources that will increase awareness and knowledge of the process of creating a will, trust, and to allow people to protect their loved ones with a proper planning and preparation in case of any unforeseen circumstances. So we strongly request all of you to make sure you take this as a priority and also share this with your family and friends. We do not want any family to suffer in case of any unforeseen circumstances. Now, coming to Allan Gassman, once again, thank you very much for doing this seminar in such a webinar in such a short notice. A little background about Allan, as he's a board certified estate planning and trust lawyer who practices in Clearwater, Florida. And he has an LLM in taxation from University of Florida. His practice areas include trust and estate planning, taxation, wealth preservation, and representation of a lot of physicians and medical practices. Allan speaks at many tax conferences. He publishes frequently, and he goes to the national programs, local webinars, including Bloomberg, BNA Text and Accounting, and Notre Dame Tax and Estate Planning Institute. He's also an author of several books, which a couple of books is nice enough to share with all of the attendees after the webinar. Thank you very much, Allan. And with no further ado, I would like to hand over this to Allan to take over and please explain us about the basics of will, trust, and estate to all of our community members.
Well, thank you very much, President. And hats off for the great job that your team has done this morning, turning my office into a studio. You obviously have a great organization, and I'm going to be a supporter of NATS because I'm so impressed with what you do for so many people. And we all know that when you do good things for people, it comes back around. And thanks for reminding us of that. So let's go to the first page. I know everybody's watching the webinar. If you have the page in front of you, we'll turn the page here. And I have a lot of articles on my Forbes blog. So if you just go to Google or whatever your place is, put down Gassman, Gassman, Forbes, Forbes, wills or trusts, you'll see a lot of these articles. And if you get in touch with me through NATS, I will try to answer questions and try to give you more resources. I have a lot of books on Amazon, and I'll give you any book on Amazon for free within 1 week of today if you make a $10 donation to NATS. So I hope you get a lot of $10 donations, and then whoever makes that. So I hope we sell a lot of books, my treat. So
thank you for the surprise this morning.
No problem, no problem.
I didn't expect this from
Yeah,
you.
so buy $1,000 worth of books, and Nat will have $1,000. Let's go to the next page here. Obviously, this is just a webinar, and the law of every state is different. So I have to say, as we say, don't try this at home. You could do this on your own, and you may be better off for trying to do it on your own, but the best way to do this is with a qualified lawyer who's licensed in the state where you are. So let's go to the next page here. I want to make it really clear that we're going to talk today about wills, and we're going to talk today about trusts, and they will control certain assets. But when you set up a financial account at a bank or a brokerage firm, if I set that account up as the Allan Gassman account, and I sign a document with the bank that says on my death it goes to my wife Marcia, then that's where it's going to go, no matter what my will says and no matter what my trust says. So you have to be aware that every account you have, whether it's an IRA, a bank account, a brokerage account, or life insurance, you have to know how it is payable on your death, and you have to coordinate that with your will or trust. The other example is when Marcia and I, my wife, we own a joint account. If I fill out the account form right, then when I die, Marcia owns it. But if I fill it out wrong, when I die, half of the account may have to go through probate and a court process. So I can't overemphasize that you have to understand how your accounts are set up and where they go on death. I also mention here on this slide that there are ways to make sure that you have found a qualified lawyer. And one of those ways is to go to the website of the National Association of Estate Planning Councils and look for a lawyer with the AEP designation. Another way is to go to martindale.com. We do confidentially peer review each other on martindale.com. The A lawyers are in the top 15%, the B lawyers are in the top 30%. You want one of those lawyers, preferably. And then there's a book called Best Lawyers in America. Everything else is pretty much advertising. So you see on the website, I'm in Super Lawyers of the Deluxe Universe. That's just somebody that you pay to be on their list. You want a lawyer who, you didn't have to pay to be on the list. Now, what is a will? A will, also known as a last will and testament, is a legal document that tells what to do with your assets when you die. So my bank account that's in my name, if there is no beneficiary designation on that bank account, my house, my dog, my car, where does that go when I die? When I die, it's no longer mine anymore. I'm not a person anymore. Everything I owned in my name becomes what is called my estate. So the house is not Allan's house anymore. It's in Allan's estate. The car's not in my name anymore. It's in my estate. And my dog is in my estate. Where do they go? And the will is a technical, legal document that directs where my estate goes and how it gets there. The will appoints a personal representative, and in some states that's called an executor if it's a male, or an executrix if it's a female. And that personal representative, executor, or executrix have to take the will document to the courthouse, to a special judge, a special court called the probate court. They take the will there and they say, my wife takes the will there and she goes, Judge, this is Allan Gassman's will. Here is his death certificate. Here is a list of his assets. He has a car, he has a dog, and he has a bank account. And he says in the will that he wants me to be appointed as his personal representative. The judge looks at the will very carefully, and if the judge sees that the will is properly signed, has clear language, is properly witnessed with at least 2 witnesses, and in some cases notarized by a notary public, then the judge admits the will to probate. That's a technical phrase. The judge says, okay, I think this is Allan's will. I admit it to probate, and I appoint you to be the personal representative, but only if you show me that Allan's children got notice of this and that nobody is objecting to you being the personal representative. Because the judge wants to make sure that no one gets cheated and that everyone gets treated properly. The judge will even require my wife to purchase a dishonesty bond. So if my wife is dishonest, she can't, the bonding company would make up for what she would steal from the estate. So this last will and testament that we're going to talk about is very serious business. She can't just take my will to the bank and say, here's Allan's will, give me the bank account. So you need to make sure that anyone that you are leaving your assets to under a will have enough cash to be able to pay for things until they get through this somewhat expensive, time-consuming probate process.
What is the typical probate process? Is it like 1 month, 3 months?
It would typically take about 5 hours of legal assistant and lawyer time to prepare the petition. Once you file the petition, sometimes the judge doesn't like it, makes you change it. Then the judge appoints the personal representative. Then the personal representative cleans out the house, goes through the paperwork, pays the bills, does the tax return, pays the IRS. That's what takes time.
Got it.
We typically open and close a probate in about 90 days when the personal representative has all the things done quickly. But if the personal representative is busy and doesn't get to it, probate can take years. And some probates take 8 to 12 years because of IRS and other situations.
Okay.
Now, the other 2 things that the will does, which are very important, is you can provide your wishes as to whether you want to be buried, whether you want to be cremated, what religious rites you would like to have occur, where you would like your ashes to be dispersed, who will pay your funeral expenses. That will go in the last will and testament. If you don't put that in the last will and testament, then the personal representative is the person who's in charge of making those decisions. And if you want to be cremated and you make those arrangements in advance, it's much less expensive and it's much easier on the family. Then, and even more important, of course, is you want to make sure that your will indicates who the court will appoint to become the new parent for your child. If your child is under age 18 and you die, it is up to the probate court to decide who is going to have custody of that child and who is going to raise that child. And the judges in the probate court are very good, and they're very gracious, and they're very caring, and they will not delay making sure this happens if they know what you want. But if they don't know what you want, and your crazy aunt shows up, and your crazy uncle shows up, and your cousin shows up, and they start arguing about where your child's going to go, your child may not go anywhere very quickly. So it's very, very important, and especially if you want your child to go to family in India, you need to be very clear with the judge as who would take care of your child until your child can get to India or until the relatives from India can come to the United States. It's fine to appoint a guardian who doesn't speak English. It's fine to appoint a guardian who's not in the United States, but like I said, think about it carefully and make sure that there's some bank account that the guardian can get hold of. If that means that you set up a bank account with $5,000 in it that goes to your aunt when you die, and your aunt knows that that's because you want to make sure your aunt has access to $5,000 to get her to be able to pay a lawyer and to put food on the table for those children the first few weeks, then that's what you would want to do.
Sure.
Does that make sense?
Yes, yes. Thank you very much for detailing, explaining the basics of will. So, will is a legal document on how you want your affairs to be handled and estate and assets distributed after you die. So I can prepare a will, but it will not come into picture till someone really, whoever has prepared it, dies. That's when
Right.
it comes into
That's
picture.
exactly right.
Okay, thank you.
And if,
Yeah, go ahead, please.
and before I forget, make sure that somebody has a copy of your will
Yes.
and that they know you have a will, because sometimes we wait weeks and weeks before we find the person's will.
Yeah, so that's my second thing. So communication, so if I'm preparing a will, maybe do you recommend giving a copy of that will to my personal representative or executor so they have it handy?
Well, sometimes you really don't want your friends to know what your will says because it may hurt their feelings.
Okay.
So what you could tell them is, I signed a will and my lawyer is Allan Gassman, and call him if I die.
Okay.
Or you entrust the will to somebody who you don't mind seeing your personal information.
Okay.
But I will tell you that you'll name someone as the guardian for your children, and then you'll go on vacation with them for 2 weeks, and after that, you'll call me and say, I don't want her to be my guardian anymore. I know her too well. I want to change guardians, and now you're going to hurt her feelings if you die. So you just have to think about that type of thing.
How difficult is it to change a guardian or an executor once I prepare a will?
Very easy. You could sign the amendment to a will is called a codicil. And you can simply have a document which says, I hereby change my will on page 4. Instead of my Aunt Becky being the guardian, my cousin Susan will be the guardian. And you sign it in front of 2 witnesses and a notary.
Okay.
If you don't sign it in front of the 2 witnesses and the notary, it won't have any force or effect.
Sure. I want our community members to start posting questions on will before we go to the trust.
Good.
In the meantime, I will have a couple of questions to ask. What happens if both parents die in an accident and the minor is maybe at a daycare or a friend's place? What happens then if you have a will and if you don't have a will?
Well, if you have a will, then the judge knows who to appoint as the guardian, and that's going to take place very quickly. And if you don't have a will, then the judge really has to size up what to do, and it's in the judge's discretion. Usually judges make a fast, good call, but they're going to want to do a criminal background check. They're going to want to make sure no one in the family is a sex offender. They're going to make sure that everyone agrees. So the child could end up in custody, for a few hours or a few days. But I have to tell you, this recent story where the child is in custody is very, very rare. In my 37 years of practicing law, I've never seen it happen. I've never heard of it happening. But as we know, it's a strange world, and things can happen. I have a couple more pages on wills here that I think the viewers may want to see while they're posting their questions.
This one, the temporary will for
Yes.
married couple and children.
Yep. Now,
Maybe we'll complete this and then I will
Yeah.
start the questions again. Okay.
so I'm sticking my neck out here, and a lot of lawyers are going to criticize me, but I have given you a will form here.
Okay.
My
thank you.
theory is if you have children and you have not signed a will, and you're single or you're a married couple, in my opinion, you're better off using this form until you get to a lawyer as opposed to having nothing. So what does this say? Because tells you, this says the undersigned, we're parents, we're married, here's the names of our children at the top, and if we both die, here's who we want as the guardians. And I've got two names, so it might be my brother and his wife. Sanjay and Anjane will be the guardians. But if neither of them can serve, then the second choice will be my cousins, Moshe and Sarah. So think about this. If your brother dies, do you want your brother's wife to be the guardian, or do you want your sister to be the guardian? So you want to think about that, but that language should suffice. Now, the second thing I say is these same people who I want to be the guardians should be the personal representatives of my estate. And then the third thing I say at the bottom is if one of us dies, it goes to my spouse. And if the other dies, then it gets held by my personal representative. We'll go to the next page now. In trust for my children. And then I say, don't sue Allan Gassman if this doesn't work. I've been encouraged to have a real lawyer look at it who's licensed in the state where I am. And then it says, we have signed below, husband and wife, or it could be, if you're same sex, that's fine, husband and husband, wife and wife. They sign, and then really, really important, whether you do this on LegalZoom, wherever, you have to have the two witnesses sign, and they have to see the husband and the wife sign, and the husband and the wife have to see them sign. And if you don't see each other sign, and you go to the judge, and the judge goes, did you see her sign? Well, no, she brought it to me after she signed. Okay, sorry, this will's no good. Your children don't get appointed necessarily. Your assets don't go there. And then the next page.
So just one question.
Yes.
You mentioned signed, right? Does it have to be notarized or just?
I don't think that it has to be notarized in any of the 50 states.
Okay.
But the notary is strongly encouraged.
Okay.
And in some states, if you don't have it notarized, you have to go through extra procedures. One of the witnesses actually has to go see the judge to promise they were there, whereas if it's notarized, the witnesses won't have to go see the judge after the death. So there is a notary provision here, and the notary has to see you sign and has to see the witnesses sign.
Gotcha.
So if you're going to do this on LegalZoom, then at least you understand how important these rules are. Now, the next document I have is the same thing, but it's for one person who is not married or who signs separate from their spouse. So if you go to the next page, just you have that. So the reason I'm giving this to you is, number one, it's an example of how simple a will can be. Number two, it tells you the most important things you want to have in the will. And number three, if you use this as a temporary document at your own risk, you can't sue me, please, then
Or
this,
NATS,
or NATS, yeah, definitely don't sue NATS. That we'll have to do asset protection planning for NATS because of this. Then
Maybe we should reiterate that this is, do not consider this as a legal advice
Right.
on behalf of NATS and Mr. Allan Gassman's
Right,
office.
right, exactly. But sometimes you help more people than you hurt. So, so now I think you have a lot of questions from the viewing audience.
Yes. Yeah. So can you have multiple personal representatives and guardians?
Yes, and it's a very good idea to have multiple personal representatives because they can work together. And quite honestly, many people will surprise you and be terrible personal representatives. They won't get the paperwork done, they won't pay the bills, they borrow the money, they can't pay it back. So if you have multiple personal representatives, they're more likely to, somebody's going to get the job done.
Okay. Maybe what I'll do, Alan, is quickly go through some of these so we can skip some questions. Maybe you can correct me. So a will should be prepared for anyone who is staying in US, irrespective of whether they're a green card or a US citizen.
Correct.
Like maybe they are on a temporary visa.
Correct. That's right.
And a personal representative or a guardian can also be anyone who stays in US, or they can be who is staying in India. So, but we need to appoint someone temporarily to take care of these minors or the assets till they come from India and take over.
Yes, and in some states, the personal representative has to be a close relative or a resident of the state.
Oh, okay.
So I could not appoint somebody in India who is not my brother or my parent or my child. I couldn't appoint a cousin in India to be the personal representative of my Florida estate.
Okay.
So that brings up a good question.
Okay.
And also, if you have assets in the United States and in India, you need a will in India and a U.S. will, and they need to specify which assets they are controlling.
Okay. So a lot of our community members, because they are on different visas or because of the nature of the job, they keep traveling from one state to other state. So let's say that I prepared my will in Florida. What should I do if I move to California?
Well, the first thing you should know is all the states do have reciprocity.
Okay.
So if the will you signed in Florida was legal in Florida, the California probate court will recognize it. But it's still safest to make sure that it does follow California law. There's a lot of really strange laws. For example, if I own my home in Florida and I have a wife and children and my will says my home goes to my wife and my children, I have one minor child, then it doesn't go to my wife. Even though my will says that, when I die, my wife only gets the right to live in the home for her lifetime, and then the home goes in equal shares to all my children, even if I don't like all my children. So that's an example of where you have to understand the state law and the different changes that the state law can make to your estate plan.
Okay. And is there any special document we need to do to set up someone in India as a guardian based on the state they are living?
Not to my knowledge.
Okay.
You just use the state law and just make it very clear. And by the way, if you haven't gotten to a lawyer and you don't want to use this form, just write an email to your best friend and say, hey, if I die before I sign a will, please let the court know that I want you to be the guardian. Okay. And I want my mother to be the alternate guardian. So the judge has something from you to know.
What happens like someone prepares a will, but they travel out of the country and they pass away there? You mentioned that the judge is going to ask about the death certificate, right? So do we need to collect the death certificate from the out of country?
Yes.
And bring it here? And
yes. Yes, you have to prove the death occurred.
Okay.
And that can take a while. In Florida, in the busy season, we can wait 3 to 4 weeks to get a death certificate from the medical examiner.
Okay. It's very unfortunate, but in scenarios like if both parents die in an accident, the guardian, personal representative, everyone are in the same accident and passes away. So even if you have a will, the next steps are to again go through the court process.
Yes.
Okay.
Yes. And that's why if you don't have a lot of assets, even though you have a will, you can make your mother or your spouse the beneficiary of your account, so they don't even have to use the will except for the guardian appointment.
So one of the I don't want maybe it's recommended as anytime you have a life-changing event like a birth or a death or divorce or starting a new business or buying an asset, do you recommend that you parallelly you make sure you make a priority to update your will and
Yes.
adjust it accordingly?
Yes. I mean, I hope everyone on this call, if you own a house, I hope you have fire insurance. If you have a wife and children, I hope you have life insurance or enough assets so that they're not in the cold if you die. And I hope you have a will. It's just one of the things you have to do as part of being a responsible member of a society. And it's just, it's an A. It's important because if you don't have it and you die, your family has problems. And it's selfish not to do it. It's not for you, it's for your family, and it's selfish not to do it. And if you're a wife and your husband doesn't have a will, you know, kick him in the behind until he gets it. Make him sign it, because people die all the time without wills, and it causes a lot of hardship and a lot of expense.
And again, the main concern is also with the minors. You know, like if you don't have a will, that there is a high probability they might end up with in a foster care,
or at least a delay and uncertainty. It's upsetting enough to have your parents die. It's doubly upsetting to not exactly know where you're going.
Got it. Yeah. And do we need to carry the original will, or is a copy enough?
A copy is fine.
Copy is fine.
The only issue we sometimes get is if you tear up a will, then you cancel it. So if we can't find the original, we're not sure if you tore it up. So then it takes an extra proceeding if the will is lost. But it's okay as long as you have a photocopy. You can almost always do fine with it. It just delays things a little bit.
So I have multiple questions again asking, if I'm a visa, do we still need to have a will and trust? Again, I want to reiterate that if you are living in United States, a will is a must. So you don't leave your surviving family members behind.
Right.
So,
cluttered and disorganized, delayed, that is the problem.
yeah. Some are asking, what is your opinion about these websites, like who can say we can get your will with $99 or $100?
You know, some of those may work, some of them may not. I've always told people that your estate plan probably costs about as much as your television. If you can afford a $4,000 television, you're probably pretty wealthy, and you may spend $3,000 or $4,000 on an estate plan. If you're watching a $99 television and because you can't afford much, then a $99 will may be okay.
Okay. Maybe we'll have for a couple more minutes and then move to the next topics. Let's say that a guardian has taken the ownership, the guardian is taking care of a minor. After 3 months or 6 months, maybe they are overwhelmed. Do they have the right to write one more will and transfer the minor ownership to someone else whom they trust?
This will be determined in the discretion of the judge in the probate court in the county where they live, and usually the judge will do what they request. If all the background checks are good, everyone in the family agrees, maybe a psychologist has examined the children, and the judge will go along with that usually.
Okay. And what else we have? Do we have to renew our will every year?
No, your will is good from the day you sign it until the day you die. The only question is whether you should change it when your circumstances change.
So in a will, do we need to include like all the list of your bank accounts or any of your asset information?
No, the will does not have to list the assets or information. It can simply say, I want everything I own. Or it could say, I want my car to go to my brother, I want my dog to go to my sister, I want the rest to go to my wife. But it does not have to specify all the assets.
Okay. Just looking at any more. So who all need to be informed upon death of someone? Let's say if I'm a personal representative, someone passes away. As a personal representative, whom should I notify?
You will send a copy of your petition that you send to the court to everyone who's a beneficiary under the will, and all people who are children or descendants of the person, or if there's no descendants, to all their siblings, all their brothers and sisters and the spouse, and then you inform the creditors. And the creditors have a limited period of time to file a claim.
Okay.
Once you inform the creditors, if they don't file a claim, they never get paid. So anyone on this call, if you get a notice from the probate court that someone died, you have to file something with the court or you can't ever sue them for your money.
Okay. So let's, thank you for answering all these questions. Let's move on to the couple more topics on who should, maybe it's not a good idea to give your guardianship and handling your assets and handling your healthcare decisions, everything to single individual. If you can also talk about durable power of attorney and healthcare power of attorney.
Right. So in the United States, if you are not able to make your own decisions and you have not provided powers of attorney, then that same judge who would appoint a guardian for your children will appoint a guardian for you. And that may be your family members, it may not be your family members, and then it's very expensive because the judge will oversee everything the guardian does. And you'll have to have a lawyer. Even if you want to sell a car, mortgage a house, you have to get permission from the judge. So you don't want to have to do that. Instead, you give a durable power of attorney that says, I authorize my wife to make all decisions for me, and if my wife can't do it, then my brother. If my brother can't do it, then my sister. And anyone and everyone in the world is able to work with my wife as if it was me. And now, when I become incapacitated, I don't have to have a guardian appointed.
Okay.
So it's really as simple as that. It's also a document that has to have the right language. If it doesn't have all the right language, it doesn't work. 2 witnesses and a notary. And it has to comply with state law.
Okay.
Most of the form books do not have an adequate Florida document. If you want the Florida document, buy my Durable Power of Attorney book for $10, which will go to NATS. That has the right form, and you can give that form to your lawyer to make sure your lawyer uses the right Florida form. The next slide simply says you can revoke a power of attorney. I don't trust my wife anymore. She's angry at me, so I revoke the power of attorney, and then she can't sign for me anymore.
How difficult is this?
1 page.
Okay.
It's very easy.
Okay. So does the power of attorney terminates? A lot of people are asking this question.
Yeah, and this is really important. The power of attorney terminates the moment I die. I gave my wife the power to sign a document for me. I die, her power's gone. She's going to have to do a probate now unless I've arranged my assets to avoid probate. Secondly, real important, if I become incapacitated, my power of attorney actually terminates unless there's special language in it which says I specifically ordain that this will not terminate this will not terminate on my incapacity. So that's 2 important things that this power of attorney needs to have. And again, it's very state specific, so if you're going to do this without a lawyer, I would use LegalZoom or another reputable website that has the state law built in.
Sure. Okay. Would you recommend, if someone comes and asks you, do you know any attorney whom you have worked or rated in other states, can you recommend?
Absolutely.
Okay.
Sure. And it's easy to find.
Okay.
It's easy to find.
So what's this healthcare power of attorney?
Well, this is even more important, I think, and this is you're lying there unconscious in the hospital and your brother comes to help you, and your brother can't even see the medical records because of the privacy laws. The nurse is not even allowed, the nurse isn't even allowed to tell your brother what's going on. The hospital lawyer ends up getting involved, and you're dead by the time anyone can talk about your health care. So my health care power of attorney names 6 people, my wife and 5 physician friends with all their personal phone numbers on it, and says, listen to any of them, and I'll pay them $300 an hour. Please come and help me. So that is what the healthcare power of attorney needs to say. It needs to say, in the event of my incapacity, any of the following people, and here's their cell phone numbers, can make any and all medical decisions for me. So anyone visiting me in the hospital can yell at the nurse and tell her to give me my Tylenol or call the doctor.
Sure.
So you need, and in the American healthcare system, I recommend you appoint people who are going to be able to be assertive for your benefit so you don't get lost in bureaucracy and not properly treated. A lot of people say, well, I'll name my 19-year-old daughter. She's very responsible. Well, your 19-year-old daughter is not going to yell at a doctor and a nurse.
Gotcha.
So you need to name your friend who will go and yell at a doctor and a nurse, in my opinion.
Glad you brought that up. And first thing is, why 6? Because when I made my estate planning with you, I always picked an odd number so we can make decision making easy. So why did you pick 6?
Well, again, I don't require in my document any agreement. I want the first person there to be able to help me.
Okay.
I don't expect my wife and my 5 doctor friends to have a big disagreement.
Okay.
If they have a disagreement, I'm not worried.
Got it.
I'm more worried about just getting anyone who can show up at any time. And if you're sometimes in India, you're sometimes in Florida, you're sometimes in California, appoint people everywhere.
Gotcha.
Give them cell phone numbers, email addresses, very important. And give your doctor a copy of this document.
Good. Because we might run out of time. Is
Right.
it okay if I jump to the
No, yeah,
trust?
please, absolutely.
So thank you very much for explaining us about the wills. Maybe we'll cover the living wills and then jump.
Yeah, I'll just say the living will is simply a document. You really need to have it. And it says, if there's no hope for me, I'm going to die no matter what. And I will die faster if you withhold life support. Unplug the machine, stop feeding me, because I want to die sooner, not later. I don't want my family to sit and watch me die for 3 weeks or 6 weeks or a year or 2 years. Just pull the plug because my brain's already dead. You have to sign the living will, and it needs to be in accordance with with state law. So that's another important document. I don't think I need to say anything more about it. It's just important to have it. But it's confusing because it's not a will. It's a document to pull the plug, and it's not a trust, but it's got the name living, so it's confusing.
Sure, thank you. So you spoke very in detail about what all things a will, why we need to have a will, what should we include in a will, whom should we make as guardians and all of this. So why don't we talk about what are the disadvantages of using a will? Tell me a couple of reasons why something else is better than a will.
The main problem with the will is that you have to go to the probate judge to get anything done. And that's time consuming, it's expensive, you lose privacy, it even makes family members fight because lawyers get involved, which isn't always a good idea.
What is the solution?
The solution is if you don't have a lot of assets, you make your assets payable on death.
Okay.
Which you could even do with a house. There's something called a ladybird deed, which says on my death, I want my house to go to my friend Kayla, and then it doesn't have to go through probate.
Okay.
But the more popular way to do it, and the better way to do it if you have assets, is a trust.
Okay. Let's go back a minute on the payable on death, right? That's very, very important thing. It does not only for the homes. Maybe it's recommended to all of your assets, like maybe when you open a checking account, saving accounts, would you recommend going back and seeing payable on death, who the beneficiary is?
You have to know, and you have to decide if it's right for you.
Thank you.
Yeah.
Please explain us about trust.
Now, I'll tell you what a trust is. There's many different kinds of trusts, but they all have this in common. There is a trustee who is an officer with a duty to do things right. There is one or more beneficiaries who the trustee has a duty to take care of. There are assets that the trustee has a duty to hold and administer. And then there's a grantor who sets the trust up, and there's a trust agreement. So an example of a trust is...
Allan, sorry to...
No, that's okay.
Can we go back once and please explain who a grantor is, who a trustee
Sure.
is, who a beneficiary is? Because first time we are here,
Right.
hearing this.
Okay. I want to set up a trust for my friend Kayla.
Okay.
I am the grantor of the trust because I'm the one who sets it up.
Okay.
I appoint you as the trustee. We sign an agreement that says that you agree to serve as trustee. You have the duty to take care of the assets I give you and to use them only for Kayla. You're gonna pay taxes as needed. You're going to invest them properly. You're gonna check with Kayla, see what she needs, and then you're gonna give her what you think she needs.
Okay.
I'm the grantor, you're the trustee, Kayla's the beneficiary, and I give you $100,000 from the sales of my Amazon books from this presentation, and you use that money for Kayla.
Okay. So maybe in a typical Indian family, if it's a husband and husband and wife can be the grantor. They can appoint a friend or a cousin as a trustee, the beneficiary being the surviving family members and the kids.
Right, right.
Did I say it correctly?
Yep, so I'm going to tell you the two kinds of trusts that 99% of the people on this call want to hear about. The first one is a trust that arises under a will. So my will says, and we saw the will language before, my will says on my death, hold my assets for my children. I appoint my friend to be my trustee, hold my assets for my children. That's really good. If it's properly drafted, the children are well protected for their whole lifetime. That's called technically a testamentary trust, You still have to go through probate to get the assets to the trustee, but it's still a very good thing for your children. So so that's a testamentary trust, a will that arises under a trust. A second type of trust is a trust that I set up today while I'm alive. I don't want my wife and children to have to go through the probate court. So I sign a trust agreement. It's called the Allan Gassman Living Revocable Trust. It's living because it's alive when I sign it. It's revocable because I can change it all I want. It's a document, and it says, I, Allan Gassman, am setting up this trust. I'm my own trustee. I'm putting my bank account and my house in my name as trustee of this trust. And when I die or become incapacitated, I want my friend to be the trustee automatically. And on my death, I want my friend to hold the assets and administer them for my wife and my children.
Got it.
And that is what you call the revocable living trust. And now I can put my house in it, my bank accounts, my brokerage accounts, my dog. And when I die, my family does not have to go to the probate judge.
Got it.
They don't have to wait for a death certificate. They simply carry on following the instructions of the trust. And that's why if you can do a will for $150, but you can do a revocable trust for $500, if you're going to die in the next 10 years or you have a lot of assets, it's a no-brainer to go for the trust.
Okay.
And that's the whole thing about trusts.
So the basic thing everyone should have is a minimum is a will. That's a must. The disadvantages of having it is the lengthy court process or the probate process.
Right.
So what you strongly recommend is at least go for a trust, and the trust can be testamentary trust or a revocable trust or irrevocable trust.
Right.
Okay.
Right.
Thank you.
Exactly.
So what are the benefits trust can provide?
Well, if you go with a trust, as I said, the trustee appointed has a duty, which in the United States we call it a fiduciary duty. It is the highest legal duty. If you are the trustee of the trust and you mess up, you could go to jail. It could be a criminal offense. So by leaving my trust, whether my lawyer is the trustee, my accountant's the trustee, my friend is the trustee, I know they have to take good care of my family. I can make my wife the trustee, but many people are concerned if my wife remarries or my daughter marries somebody who has a forceful husband, they may take advantage of my wife. So it is normal to say that my wife will be co-trustee with her choice of another person named in the document, or every bank, just about every big bank, has a trust company, and they can provide trustee services, or Vanguard, Charles Schwab. They all have trust companies. If you entrust them with your assets to take care of your family, it is a very safe bet that they will do a good job.
Okay.
If you appoint Uncle Joe, who you don't really know that well, it may not go so well.
Got it. But let's say that in a family, the surviving family member, the spouse survives, can she change the trustee because Uncle Joe is giving a hard time? So
Yes. So typically the documents say, and as you know, because you've helped me design documents, this document can say, on my death, my wife will choose her choice of Uncle Joe or a trust company or our accountant, and she can change who the trustee is, but she has to stay with Uncle Joe, a trust company, or an accountant,
got it.
so that our son-in-law or the next husband can't come in and take advantage of her.
Okay. And you mentioned about a trust company managing the trust, right? I just want to have my community members aware that there is a small fee associated with the trust companies
When they start to serve.
when they start.
When they start to serve. And Vanguard and Fidelity and other trust companies charge much less than many other
Got it.
trust companies.
So the best,
Yes.
maybe the best recommendation here is have your trust done because it has somewhat you don't have to go through the probate process. Have your surviving family member and couple more Uncle Joe and Aunt Shelley or someone, and give power to your surviving family member to change the trustees on as needed basis. And everyone has a fiduciary duty to make sure that they maintain the trust carefully.
What you just said is really, really valuable advice. And when I speak to lawyers all over the country, they haven't thought of that.
Oh.
They typically only appoint Uncle Joe with no ability to get rid of Uncle Joe. So what you just said is vitally important to everyone on this call.
I mean, while working with you, I mean, I always pick the number 5. My magic number is 5. So there are enough backups people. So
Yes, that's important too, because so many people only pick one person in a backup. Well, one person gets sick and the backup doesn't want to do it. Please remember that families fight.
yeah.
And when the family fights, no one wants to serve. So that's where you would say 4 family members, but then Vanguard Trust Company as the last choice. So if the family starts fighting, somebody will serve.
Alan, how is your time looking like? Can we extend a little bit more?
Sure, sure.
12:30, is that fine?
Mm-hmm.
Okay.
Yeah, no
'Cause
problem.
You're giving us so much knowledge, and I want to make sure my community members get advantage of it.
No problem at all.
So what benefits can trust provide?
So another benefit that a trust provides is that if I leave a trust for my children and it has the magic language, the trustee will use the trust for their health, education, maintenance, and support. And for only those reasons, now a creditor of my child cannot reach into the trust. So instead of leaving my money to my friend Kayla, where her creditors may reach it, her husband may reach it, I can leave it to Kayla as trustee for herself, for her health, education, maintenance, and support, and now creditors can't touch it. The IRS can't touch it. It's completely creditor proof as long as I set it up for her. It's not a trust I set up for myself. So when you have a will or you have a living trust, don't have it say, these assets go to my children, or these assets are held for my children until they're 35 and then they receive it, because then they may get lost in a divorce, the IRS may take it, a car accident causes a creditor to take it. So the trust, if it's properly drafted, will keep creditors out, and will also, if Kayla wins the lottery and her estate is over $11,450,000, which I hope it will be, when she dies, that trust will not be subject to estate tax.
Okay.
As well. And it will also avoid the state estate tax. So if she moves to New York and has more than $5 million, and that magic language is in there, then the state of New York will not impose their inheritance tax on
So
it.
you brought up a good point about the estate tax, 11 million. That number keeps changing every year, I believe, right? Maybe not every year.
It's now actually $11,580,000
For each individual.
for
right?
each individual.
So if it's a family, it's like 22.4.
Right, right. But it's scheduled to go to half of that in 2026, and the Bernie Sanders plan is for it to go to $3,500,000.
So what happens if your asset is more than 3 million?
or more than the estate tax amount,
More than the estate
then it's a 40% tax.
40% tax even if you are giving to your children.
Right. If you give to your spouse, there's no tax because there's something called the marital deduction.
Okay.
But if you're over the 11,580,000 and it goes to your children, it's going to be subject to estate tax. And that's a good reason to leave it in your will to charity, like NATS. Because if you leave it to charity like NATS, then there's no estate tax. Don't forget to put NATS in your last will and testament.
Thank you.
Sure.
We don't want to scare our community
Okay.
members. We're moving to the next slide.
Okay, so as I said before, if I set up a trust during my lifetime, which owns my assets, then the assets don't go through probate when I die. They don't go through guardianship if I become crazy. They don't get disclosed in the probate court where other people may be able to find out about them.
Can I just stop you here for a minute? Maybe we didn't cover the point that if you have a will, what everyone needs to understand is it's going to be a public record. When the personal representative goes with the will and he goes to the court, anyone can access the will.
In most states,
In
yes.
most states.
That's
but
right.
if you have a trust, then it's not a public record.
Right. And let me mention, when you set up a trust, you will also set up a simple pour-over will. Mm-hmm. A will that says, on my death, put everything I have into my trust.
Okay.
And then the trust has all the language, which will remain private, and even the probate judge won't find out about it unless there's litigation or other situations that would come up.
Okay. You want to cover avoiding taxes?
Yeah, I think I've mentioned
Okay.
these things. Now, I will say, I can set up a revocable trust for myself. It will not avoid my creditors. It will not allow me to qualify for Medicaid. So I'll mention a couple things that we don't have slides on, I don't want to forget. The Medicaid rules are very, very complicated. But if you are in the United States and you need nursing care, you can often qualify for Medicaid and receive hundreds of thousands of dollars worth of worth of free nursing care from the government. But if you break the rules and you give assets away, then you can be disqualified from Medicaid. So if you have an elderly parent and you're trying to think about whether they should gift or not, you want to probably talk to a lawyer who specializes in Medicaid planning to not mess that up. The other thing I don't have a slide on, but I want to talk a little bit more about being a responsible member of your society, term life insurance. Buying term life insurance. And I say term life insurance because term life insurance is life insurance where you pay the carrier so much a year or so much a month, and if you die, your family gets a big check, and if you make it payable to a trust, it can be protected for your family. 99% of the people on this call do not need whole life insurance or permanent life insurance. If you buy term life insurance, it may cost you $1,000 a year for a $500,000 policy. There's no cash value, you don't get anything back unless you die, but you just pay your $1,000 and your family gets a big check if you die. With permanent insurance, you make a much larger payment and it will develop a cash value, but almost every time, a lot of money goes to the salesperson and less money ends up with the family. So if you're going to buy life insurance, first figure out how much you need, then then take your medical exam. Once they've given you your medical exam, which is free, they'll tell you the prices. And keep in mind, when the salesman says you could buy term, you could buy permanent, the salesman makes a ton more if you buy permanent. And I'm not really popular among the life insurance people, if you could guess.
Sure.
But I think ethically we have to let everyone know, buy as much as you're going to need and be much more worried about buying the right amount of death benefit than developing a cash value. And
Allan, you brought up a very, very, very good point about everyone. First thing is the will or the trust. The second thing is must have life insurances. A lot of employers have this option where you pay like $1 or $2 every month and you can enroll in their life insurances. But the disadvantage of doing that is once you change a job or your job is terminated,
Oh, yeah, it's gone.
you lose all those benefits.
Yeah.
So
Good
it's
point.
always better that you have your own term life insurance, which might cost as low as like $50 to $100, and have a minimum amount so that if something happens, that your spouse has some chunk of money immediately to pay all the bills. And thank you for suggesting that whole life insurance is not that recommended. Go for term life insurances for 5 years or 10 years or 15 years.
Right.
Thank you very much.
Or even 30 years.
Or
Sure.
even 30 years. Thank
Yep.
you very much for
Sure.
bringing that up.
Absolutely.
Well, can we go through some of these maybe scenarios so our members can understand better?
Right. So I have an example here, and you can read these slides later.
Okay.
But I have an example here of Jane. Jane is the mother of Sally. Sally is 16, and Jane has a house. She's got a brokerage account at Schwab, maybe. She has a bank account, and she has an IRA. And if Jane dies without a will, Sally's really out of luck. Because first of all, Sally's only 16, and when you die without a will and without instructions, the court is now going to appoint a guardian for Sally, and that guardian is going to receive these assets, and when Sally turns age 18, the guardian gives her the assets. And then they go to Sally's boyfriend, and they're lost forever. You have a question?
So when you said the court will have a guardian, how do they decide that?
They'll have to decide it. If you don't have a will that gives them guidance, they'll have to interview family members and try to see who they recommend. And for a 16-year-old, they'll also interview the child.
Oh, okay.
And if the child is 12 or older, usually the court will interview the child or have a psychologist interview the child. Now, Jane may have made Sally the beneficiary of her IRA, and that will avoid probate, but still a guardian will have to be appointed because the child is not age 18. And in 3 of the states, it's age 21 that the guardian would have to be appointed until. So if we go to the next page.
She goes to the financial.
Yeah, she goes to the financial planner, and the financial planner advises her to set up a will.
Okay.
And the will says, when I die, my friend will be the trustee, my friend will be the personal representative, hold the assets for the lifetime of my daughter, and now you don't have to worry about the guardianship for the daughter, but you're still going to go through the probate process. Exactly.
Which is time consuming and lengthy.
Right.
It's a public record.
Public record and all that. So now this is where we talk about the testamentary trust that I said, a trust that arises under the will, and she can make the IRA payable to the trustee of the testamentary trust. So when Jane dies, the court recognizes the trustee under the will. The IRA goes to the trustee, so that is what you call a will with a testamentary trust, which is fine for most people. Now, the next slide, let's see what happens next.
The bank account.
Yep. So now the CD, the bank account, can also pass to the testamentary trust to avoid probate. So she's going to pay attention to that. And then we'll go to the next slide. And on the next slide, I'll have to read the above there.
Sorry.
Yeah. So now she's going to talk about the revocable trust.
And pour over.
And a
will.
pour over will, right. So she's going to form, if we go back down, we'll look at the picture there. I guess let's go to the next one, the next slide. So here, now she is the owner of the Jane Smith Revocable Trust. She has her CD and her bank account under the trust. If she lives in Florida, she may keep the home in her own name for creditor protection purposes, because in Florida they can't take your home, but she can do what we call a special ladybird deed, where the home would go to the trust in the event of her death, and the same would apply her life insurance policy, and her IRA would also go to the trust in the event of her death by direct beneficiary designation.
So we have seen multiple scenarios, right, and where Jane is having no will, and after 18, Sally can have all of the assets, which is not recommended to go that way. And then we saw will with testamentary trust, which is somewhat better than the will, and now we are talking about the revocable trust, which is well defined, much more protected in terms of your assets and passing through your assets to your surviving family members.
That's exactly right.
What happened after 18? They become a major and they have all the assets to them, right? And they can able to do whatever they want with the assets, or you can able to define any guidelines, say they can't go and buy a Ferrari with my property. Right?
Well, the normal way that it's done, I don't like and I don't recommend. And the normal way it's done says, when my child's 25, she gets 1/3. When she's 30, she gets half the rest. When she's 35, she gets the rest. So the first third she blows because she's 25 years old and she spends it on drugs. The second third she loses to her first husband. And then the last third she builds a restaurant and it fails. So it's much better to say that when she's 25, she can be co-trustee with Uncle Joe, but she only gets what she reasonably needs for health, education, and maintenance, and she better be working and going to school or raising a family. And then at 35, she can get rid of Uncle Joe, but she has to have a trust company. And yes, Vanguard will charge 0.5%, but it'll be safe, and that's safer for her. And some clients say she can't get more than $5,000 a month out of this thing until she's 65 years old because I don't want to spoil my children. I want to teach them to work. They can spend it on their own children and for medical emergencies, but no Ferraris. They can go get a job and buy their own Ferrari.
Okay. So this is the next slide. The trust continues for.
Right, and this just discusses, as I said, how the trust will continue after Jane's death for Sally, for Sally's entire lifetime, or at least until a very old age. And then I mentioned in Florida, you would not put your life insurance policy or your annuity agreement in the name of the trust because then creditors could reach those things. So this is where, I don't think you would have figured that out from LegalZoom.
Okay.
Quite honestly, you may be the most, intelligent electrical engineer that was ever born. And if you try to do your estate plan and you have these types of assets, you will make mistakes. So you'll need a lawyer to fix them. I think LegalZoom maybe has a lawyer program where the lawyer reviews it. If you're going to use LegalZoom, I would have the lawyer review it if you can afford that.
Okay. Maybe the first step is whether they use a lawyer or an online site or like some software. First step, again, is what is important is you have at least something in place.
Yes.
Which is will.
Yes.
Then or the time, maybe then you go back and look at it and say, hey, maybe it's a good time for me to hire a lawyer to go through all of these nitty-gritty details.
Right. That's exactly right. So now we buy the life insurance. Typically, Jane's the owner of the life insurance, so it's creditor protected, and you make the beneficiary of the life insurance the living trust. If you're a husband and wife and you're doing an estate plan, we want to make sure that when the first spouse dies, let's say it's the husband, because it's usually the husband, that's not going to go to my wife. It's going to go to a trustee for my wife. It may be my wife as trustee. She's going to be able to spend it, as I said before, for health, education, maintenance, and support. So her creditors can't take it, her friends can't take it, my son-in-law can't take it. And when my wife dies, I don't want to receive it either. I want it to go into a trust for me.
We're talking about the annuity contract.
Yeah, same thing with the annuity contract. And then the last slide here, so we're actually finishing earlier than you thought, but I'm sure you have a lot of questions. The last slide here gives you a typical estate plan for successful people, where in most states, the wife will have her own revocable trust, and that will be the beneficiary of her life insurance. And when she dies, that trust becomes irrevocable. It's held for the husband and the children. And then the husband will have his own revocable trust. And then you may have a trust for the children as well. And you can start putting assets away for your children. And if you're successful here and you have children, some of your assets will probably go into what we call a 529 college savings plan, where they are creditor proof and you never pay income tax on the earnings as long as it's spent on school, but you can still spend it on yourself if you need it. Or, as I said, you can have a trust for your children. So at the bottom here, this family has real estate. We always put investment real estate in a limited liability company, so when the tenant trips and falls and breaks her neck or dies in a fire, they don't sue the family, they only sue the LLC. And then we have the family business. The family business does not own the real estate, because when somebody gets hurt in the family business or sues the family business, we keep that separate from the real estate. And then when we have the intellectual property, we put that in a separate LLC, so when somebody sues the business, they don't own the name, they don't own the patents, they don't own the trademarks. And then sometimes for tax purposes, we set up a management company. And then we have these LLCs at the bottom owned at least in small part by the trust for the children. And then under the state law, if somebody sues the husband or the wife or both of them, they can't reach into these LLCs and take the family. So, I mean, what I'm describing here works differently in every state. There's 100 different ways to do it. It definitely takes a lawyer. You won't get this on LegalZoom, but it just gives you an idea. So many families are sitting ducks. They have their real estate in the same company as their factory. They have no will, they have no trust, they have no creditor protection, they don't have enough insurance. Most people who come to us, especially after a serious accident, didn't understand how much risk they were taking and how much insurance they should have had. You know, car insurance, liability insurance, things that as you guys are successful and as you're contributing to your community, please be responsible for your family. Please have a good CPA, please have a qualified lawyer and get this done, because otherwise, quite frankly, there's probably a 2 in 100 chance that you'll lose it because of a car accident or a fire or who knows what else.
A slip and fall.
A slip and fall, yeah.
As you brought this up, I want to bring one more topic. I mean, if you have a reasonable number of assets, then would you also recommend them having the umbrella policy?
Absolutely, absolutely. If you can afford at least $100,000 of liability insurance, you need at least $100,000. I think if you can afford to drive a decent car, then you can afford to have $100,000 of insurance. But it's much better to have what they call an umbrella policy, which is $1 million. So it's confusing, but the way insurance works here in the United States is you'll have one policy usually for your cars. That's usually $100 to $250. And then you'll have one policy for your home. That's your homeowner policy. That's usually $300,000 of liability, plus it'll replace your home in a fire. And then to get coverage above that, you have to pay for a separate third policy called an umbrella. That umbrella may cost $1,000, $1,500 a year. If you can afford a nice car and you can afford a nice house, then you can afford an umbrella. $1 million may cost $700 a year. $2 million may cost $850 a year. $5 million may cost $1,200 or $1,400 a year. You need that coverage for an accident. When somebody gets hurt in a car accident in the United States, if their finger is not going to be the same as it was, that can be $1 million. It can be $5 million if they're a surgeon for a finger, let alone if they can't use their hand anymore. Juries are very generous here in the United States. So you need plenty of coverage. And don't let your children drive your cars, because you'll be liable for the accident. Put the cars in your mother-in-law's name or something like that. Let them be responsible for your child's accident. And there's more information on this in my Forbes blog.
Oh, okay.
And on my Amazon site, which for $10 donation to NATS, I have books on creditor protection and business protection and protecting doctors. So
Okay,
Drum it up for NATS.
sure. Thank you.
Yeah, sure.
So, I mean, in this whole webinar, the main takeaway messages is will is for every person who's staying in United States. Then you can take it to the next level by trust. If you are probably settled here, if you're more than like maybe 4 or 5 years, you have accumulated some assets, go for a trust. Or maybe you can do will with a testamentary trust, or you can do a trust with a revocable or irrevocable things.
Yes,
Right? Okay.
exactly.
And also, don't forget to take life insurance. It doesn't cost you a lot. Don't forget to also, maybe it's a good idea to buy an umbrella liability insurance, which will also cost maybe $50 to $100 depending on the coverage.
Yeah, let me mention one other thing with one of the big expenses of the umbrella is that it comes with extra insurance called uninsured motorist coverage. If you get hurt by somebody else and they don't have enough insurance to pay for your injury, your own insurance carrier will pay for your injury if you have uninsured motorist. And I have had clients receive $1 million checks from their own insurance company for uninsured motorist for nursing care. So please, when you drive in the United States, we know it's dangerous. So you want to have enough liability insurance and enough uninsured motorist coverage, or quite frankly, at least understand how the asset protection rules work and make sure you have your assets in a way that creditors will be less likely to be able to touch them if you're doing anything dangerous.
Okay. So now maybe we have 13 more minutes. I want to open the floor for question and answer sessions.
Great.
So what are the additional considerations for parents with special needs children?
The most important thing for a parent with a special needs child is to make sure that the trust is competently and carefully drafted with special language, which basically says, if and when my child would ever be able to qualify for public assistance, the trust cannot be spent on anything that would disqualify my child. So if I leave a trust for a child that says it's for the child's health, education, maintenance, and support, then the child cannot get government assistance. But if the trust says the trustee can spend money on anything other than what assistance pays for. It can buy special nursing, it can buy birthday presents, it can buy trips, it can buy friends, it just can't pay for food, clothing, or shelter. Those rules are different in every state. You're going to need to go ahead and go to a lawyer who specializes in that area. They are usually called elder lawyers, or good tax lawyers understand these rules. So
Okay,
that's
thank
my
you.
answer. Sure.
So if we put like maybe an executor, trustee, or a guardian who's outside of US, they come here, they don't have an SSN account. So how does it work? How can they operate the bank or get their name added in the bank account?
When the bank looks at the will or looks at the court papers or looks at the trust agreement, they will allow them to sign on accounts.
Okay.
They may have to apply for a U.S. Social Security number and show ID by passport, but they won't have to do much more than that. The other thing the banks are going to want is to see a utility bill in their name to show that they actually live at the address where they say they live.
Okay.
Otherwise, it shouldn't be a problem.
A lot of our members have assets in India as well as here. So how do we link those two? Like if they have a will or power of will or a trust in India and here, how can we?
What we normally say is that it is my intent that this will that I am signing will cover all of my assets. But at the same time, they need to go to a lawyer in India and make sure they have the same will in India, basically. A mirror image will or whatever the lawyer in India recommends. And every province in India has different rules, and then your ancestral property rules are very, very complicated. So I doubt that LegalZoom does India wills, but I'll be delighted if they do.
Sure. The estate tax, does it differ for a U.S. citizen, green card, or someone who's on a visa?
It is the same for citizens and green card holders. Someone here on a visa, that's a really good question. They are subject to estate tax on assets over about $150,000 if they are not a green card holder.
Okay.
So they need to do special planning by keeping the assets outside of the United States or putting the assets in an LLC.
Okay.
Because an LLC is not considered to be a U.S. asset. So, but they need to see an international tax lawyer.
Okay.
Not just any tax lawyer, they need to see an international tax lawyer to make sure that that gets done correctly. They also, the bank accounts will not be counted.
Okay.
But a car will be, and a house will be. But a house in an LLC may not be. So, very good question.
Okay. And the umbrella insurance, does it cover only in US or even when they travel out of country?
I don't know. That's a good question. I think some of them probably cover only in the US. Some of them may cover worldwide. That's a great question.
So a lot of questions are coming asking what is the fees for will, trust, your fee as well as the general outside fee. They have to,
Like I said before, it can cost hundreds of dollars. It's going to cost at least hundreds of dollars if I do it, to do it right. And it's often going to cost thousands of dollars. It's going to cost, for a lot of you, it's going to cost what your television or home entertainment system cost. If you paid $20,000 for a theater home entertainment system and you have a $5 million net worth, you may pay $5,000 to $7,000 for a good estate plan.
but for a will, because most of our audience are on temporary visas. So for a will, what is...
I would think a will with a power of attorney package is probably going to be about $300 to $400 usually.
Okay.
And one of the things I think you're sending everybody is our information gathering form. And what I would encourage you to do if you want to spend less money but still get a competent lawyer is fill out our form and send our form to a law firm and say, I don't have much money, but I want to get an estate plan. Here's all my information. Can you please estimate what it would cost?
Okay.
That's going to impress the lawyer because quite frankly, 2/3 of the time I spend on estate planning is trying to get the clients to give me the darn information and spending time interviewing them, and they say, oh, I thought I had a house. I don't really have a house. I'm not sure how the house is titled. If you give all that information to the estate planning lawyer with copies of your brokerage account statements and copies of the deed of your house, and you send that all to the lawyer and say, I want to know how much this is going to cost, it's going to cost a lot less.
Okay. So I will be your estate plan quick start. There are two advantages with it, right? The lawyer can give you a ballpark, mostly precise fees on how much assets you have. The second thing is this exercise will also help you to put everything in your piece of paper and also share it with your family members.
Right.
Because a lot of times, maybe not everything is shared to the other family members. So this is a good time to consolidate all of your assets and put in a piece of paper and then use that estate plan quick start list to get a quote from other attorneys on how much it's going to cost.
Right. There are non-lawyer estate planning services. Avoid them like the plague. I would much rather you use LegalZoom on your own than use a non-lawyer service because this is complicated stuff, believe it or not. And in my experience, the non-lawyer services make a lot of mistakes. And so use a lawyer who's licensed in the state where you are. But if you give them all the information and explain to them that you have limited assets, but you're trying to be responsible for your family, they'll usually give you a much lower price than you would otherwise pay.
So one of the questions they're asking is, they're asking NATS if we can do a one-day, maybe one more seminar, like a workshop on will and trust documents.
I would love to do that. I do those all over the country.
Okay.
So I would love to do that.
Okay, thank you.
We could do one for married people, one for single people, one for people with parents. We could, do as many as you like so that it caters to the people who are going to be on the call.
Okay. What will happen to the Social Security money which we will be getting once after age 63 or 65?
It goes directly to you.
To trust? Should we put it to the
Yes,
trust? Or?
you can ask Social Security to make the check payable to an account under the trust.
Okay.
That's a very good point.
Okay.
And it's creditor protected under the federal law.
What about 401k?
The 401k is also creditor protected under the Florida law. and on your death, it will pass into your trust. While you're alive, you will, when you stop working there, you'll roll it into an IRA. It'll stay non-taxable until you pull it out. It's creditor protected in most states, and you'll make the IRA payable usually to your spouse, because when you die, your spouse can roll it over into her own IRA, and she doesn't have to start taking payments until she's over age 72 and a half. If you leave the IRA to a child or a trust for the child, they have to take it out within 10 years of your death under the new tax law.
So we are running, we're top of the hour, so can you give some takeaway messages for our community members?
Sure. The most important thing is that you make a personal commitment of the time and the money that it takes to be a responsible family member and to have your estate plan done. I hope that if I would give you 15 seconds of silence here to write down what day you're going to get this done and that you're going to get it done, that's what I would do. I cannot tell you how much sadness and misery I've seen in my 37 years of practice when people get sick or they die and they haven't got that done. So that's number one. Number two, at least get a will in place. If you're a procrastinator and you're going to get it all done properly eventually, at least get a simple will in place. Heaven forbid something should happen before you get this trust in place. Number three, carefully review how your assets are titled. Find out where they go when you die, if there's beneficiary designations. Find out whether you have enough life insurance. The rule of thumb in the United States is that when you die, your family can live on 4% of the value of your investments for the rest of their lives. So if I'm leaving $1 million, that means my wife will have $40,000 a year the rest of her life. If she needs $80,000 a year the rest of her life, I better get another $1 million of term insurance. Call and take the physical. They can't really give you real numbers on prices until you've taken the physical. Once you give the physical, they'll give you the prices. Buy as much death benefit as you need. You can buy term insurance. It's still convertible to permanent later, so get as much as you need. Decide whether your will have a testamentary trust that opens up when you die, or whether you will go the extra mile and have a revocable trust. If you're married, I think in most cases, if you're going to do a revocable trust, at least talk to a lawyer and make sure you do the right kind of revocable trust. If you live in California or Texas, it's usually going to be a joint trust because of their laws. If you live in Florida, it's usually going to be separate trusts. It can vary. So again, whatever you spent on your home entertainment system, you can spend that every 5 or 10 years on your estate plan. Be careful of who you trust as an advisor with your investments. That's something I haven't mentioned, but time and time again, people come to me and they went to a free lunch presentation given by a lawyer who gave them free information about wills and trusts, and a financial planner who gave them free information about investments. And they bought an annuity contract or a mutual fund where the investment advisor made an 8% commission and they only got 92% of their money into the investment, and they never knew, because these things do not have to be disclosed in the United States. So that was a very expensive lunch. In fact, they ended up pushing back their retirement by 5 years because they lost 8% of their assets to a bad investment advisor who then charged them 3% a year above that instead of going to Vanguard and paying 0.5% a year. So watch what you're doing very carefully. Make sure your parents have given you powers of attorney, so when they're visiting you, you can sign their name for them. Make sure that any inheritance you're going to receive is going to a trust, which will not have to go through probate. Make sure that you have good financial and healthcare powers of attorney underway. And take care of your health too. We have a lot of people who come to us with dying of cancer, and they wouldn't be dying of cancer if they had had an annual physical, an annual blood test, an annual check of their prostate. Do all that stuff so that you won't die and have to worry about whether your documents are right. But we find that clients who take care of themselves physically, exercise, it's less stressful if you have less weight on you, take care of yourself, take care of your family, you'll live longer, you'll be wealthier. And finally, support a good charity like NATS. Because scientific studies have shown that if you're charitable and you help other people, you will live longer and you will be more prosperous. There's no doubt about that. There's a great book called Why Good Things Happen to Good People, and it's based all on peer-reviewed scientific evidence, and it's absolutely true. So I hope when you prioritize today, it's a nice weekend, you can sit down, think about your priorities, make sure the A priorities include your health and your estate plan and your prosperity. So that sums up what I
Sure.
appreciate having the opportunity to say.
Allan, we can't thank you enough for your time and educating all of your community members, all of this. You have done an excellent job, and also for the community members, I have used Allan's services for my own estate planning, and I was very much happy for having Allan to guide me on the do's and don'ts. Thank you once again, and we will hope to conduct more webinars like this. We will send, and Allan is also very generous to share his electronic copies of books authored by him. We will be sending out an email for a link to download the copies of the books. We will also upload this video to natsworld.org website, and we will also make sure we communicate to you about the next webinars on this particular topics. Thank you everyone, and if you need any assistance, if you have more questions, you can email us to helpline@natsworld.org, and we'll consolidate those questions and send it to Allan's office. And we will also send you Allan's company website, so you can reach out to their law firm if you want to hire their services. So thank you all for participating, and hope this webinar is very informative. And as Allan suggested, please take this as a priority. At least start off with a will. Make sure that your family members are protected. Planning is very, very important. And we have seen many incidents without having this planning and preparation. They have to go through a lot of pain. So I would strongly recommend that you keep this as a monthly goal and get at least a will done.
Let me mention also, there's a lot of webinars on YouTube. If you search Gassman webinar, you'll see many webinars. And what you'll also see, most of my webinars on YouTube are intended for CPAs and lawyers to learn about estate planning. And you will see the complexity as I explain it to lawyers, and then you'll understand why it costs as much as an entertainment system.
Sure.
We're not just pushing a button on a computer and collecting $1,000. It's a lot of work.
Sure.
So thank you very much.
Thank you. And once again, I want to thank my team, Srinivas Malladi, Rajesh Kandru, Sudair Mikilneni, Kayla from Allan's office, Debbie, and Matt, and also Vijay from Cloud Mellow. Thank you everyone for giving us this opportunity to host this webinar in short notice.